Jeff to cover something he would like everybody to know before we get into the course material. Jeff, take it away, sir.
Thank you, Jeffrey. Hello, everybody. Thank you for joining us on what really is one of our first events. Need to do a big shout out to our Valencia group that's joining us for having inspired today's educational seminar, 4 classes in a row, 1, 2, 3, 4. So that was good, and glad we could accommodate them. Glad we could offer this opportunity to everybody that is participating. On September 17th, the United States Department of Housing and Urban Development, HUD, which oversees the Fair Housing Administration in the federal government, came out with a very interesting memorandum. The liberalness of and interpretation of the assistance animal rules, regulations, and statutes as interpreted by the Fair Housing Administration, when they do those interpretations, they issue bulletins. Those bulletins are as if what the local OEO, Office of what is it? OEO, Office of Equal Opportunity. They have jurisdiction to review the fair housing complaints. At least that's the organization. In Palm Beach County, every state, every county could have a slightly different designation, but they all rely on these bulletins for how the federal fair housing laws themselves are to be interpreted. As you know, the present administration in the White House, and as a result of some orders through the White House, as a result of a recent United States Supreme Court court case, which held that agencies have gone too far in promulgating some of their rules and regulations. So the U.S. Department of Housing and Urban Development came out with a new brochure on September 17th, 2025. I'm going to read selected parts of it. The Department of Housing and Urban Development has issued non-binding policy guidance in myriad forms over its history. The guidance has taken the form of guidance documents, interpretive rules, advisory opinions, and policy statements. In some instances, guidance promulgated by the Office of Fair Housing and Equal Opportunity may have adopted interpretations that are inconsistent with the statutory text and purpose to impose compliance burdens on regulated parties outside of the strictures of notice and comment and rulemaking guidance. The Office of Fair Housing and Equal Opportunity is conducting a review of its guidance documents and has determined to withdraw all guidance materials identified below, which I will read to you. However, the withdrawal of these advisories' opinions are not necessarily final. And then they give a list of opinions they have withdrawn. One of them deals with service animals and assistance animals for people with disabilities, promulgated on April 25th, 2013. Another one, assisting a person's request to have an animal as a reasonable accommodation under the Fair Housing Act, promulgated January 28th, 2020. And there are a bunch of others as well. But the bottom line is all of the advisory opinions at the moment are withdrawn, but yet that withdrawal is not final. Why do I mention all this before Ben gets started? Because generally speaking, those documents are used by attorneys to see how HUD will view a particular situation, and we then give guidance. So Jeff has a disability. It affects him at work. Having an animal at home makes Jeff more productive when he's at work. That's the minimum showing. I have a disability, a recognized, federally recognized disability. Bet I'll go through all that with you. And it affects me at a major life function, working being one of those major life functions. I'm picking on myself just to draw out the example. And it's the interpretations of who can prescribe the assistance animal and such are extremely liberal under the last 8 to 12 years or so through HUD and the Fair Housing Administration. It is extremely liberal in its interpretation of who's entitled in the no pet communities, have an assistance animal. We don't know yet how the withdrawal of these advisory opinions is going to affect you, going to affect our client base. On the one hand, they say, well, we've withdrawn these opinions, but it's not final. So we really don't know what it means yet and what the implications are. So the purpose of me coming out today and giving this little introduction was, one, I wanted to say hello to everybody, and two, was to make you aware that this is an ever-moving target right now. Because of this withdrawal of these agency opinions, we don't know what it means yet in the real world, and time will tell. So I'll certainly be publishing as we learn more. All right, but I wanted everyone to be aware of that. We're still going to teach the class as if these advisory opinions still exist. The material that Ben is going to go over with you, some of it does come from these advisory opinions. And just because they are withdrawing the opinions doesn't necessarily mean they're still not going to rely on them later. Remember, that's not final yet. This is an interim step. We have to see where it's going to go. I thank you all for joining us. I'm relatively certain everybody here that's with us today is already familiar with our law firm, so I won't bore you with a tremendous amount of details, except to tell you we cover associations throughout the state of Florida, and it's our pleasure to give back in this way of giving these webinars and seminars and such. Whether you're a client or not a client, it's our way of giving something back. So I wish you all a very happy holiday, and I thank you for joining us today. And now I turn you over to one of our great presenters, Attorney Ben Heydlauff.
Thanks, Jeff. Appreciate that. Again, good afternoon, everybody. My name is Ben Heydlauff. Yes, I am one of 25 or so attorneys here at K. Bender Rembam. Just so that you all have an appreciation, prior to practicing community association law, I was actually in the world of family law. So you talk about one guy who really needed an emotional support animal. Boy, oh boy, that was me in a prior life. Having said that, my first career was in HR, ended up in law school later in life, and I will leave it at that because we are going to be severely time limited. We have many, many slides to get through and very limited time to do that, but just kind of as a 30,000-foot overview, we're going to be talking a little bit about the Americans with Disability Act. We're going to be talking a whole lot about the FHA, the Fair Housing Act. We're going to be discussing service animals as compared to emotional support animals, and talking a little bit about association policies, procedures, and what is involved in all of that. So I will kick it off with kind of a larger overarching policy and enforcement view. So essentially, it's the policy of the United States, the public policy, to provide within constitutional limitations for fair housing throughout the United States, and certainly is a noble goal. Now, the Department of Justice, dun, 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 and if any of you have the law and order theme running through your head, I don't blame you. But the DOJ and the Department of Housing and Urban Development, HUD, as Jeff Rembam mentioned, are jointly responsible for enforcing the FHA, otherwise known as the Federal Fair Housing Act. And so we call it the Big Seven. So the Fair Housing Act essentially prohibits discrimination in housing on the basis of race, color, religion, sex, national origin, familial status, or disability. However, we can't neglect to check the state and local ordinances as well. And so in our neck of the woods, Chapter 760 of Florida statutes is Florida's version of the FHA and is enforced by the Florida Commission on Human Relations. And we also have local ordinances. For any of you here in Palm Beach County, pursuant to Palm Beach County's code, discrimination is prohibited on the basis of sexual orientation, age, marital status, and interestingly enough, as compared to the FHA, gender identity or expression. And now we're going to kind of compare and contrast the United States Code versus the CFR, which is the Code of Federal Regulations. So the United States Code contains statutes that are enacted by Congress. And certain laws contain what we call quote unquote enabling legislation. And essentially, that creates governmental agencies, and they're vested with the power and authority to create rules and regulations. And they do this by following a legislatively created administrative process that provides for both notice to the public and the invitees and invites for public comment. Now, comparing that to the Code of Federal Regulations, i.e., the CFR contains the rules and regulations that are actually adopted by the governmental agencies. And essentially, these rules and regulations are intended to further the legislation that's been adopted by Congress, and they've got to be consistent with the agency's enabling legislation. And interestingly enough, these rules and regulations that are promulgated are just as enforceable as the United States Code. And if you want to learn more about the FHA, it's incorporated into the Code of Federal Regulations. It's under Title IV, which is Housing and Urban Development, and it's in Part 100. And it contains a number of subparts, and you can see them there on the screen. Because we're in a time crunch, I will not read them all, but essentially subparts A through G. Now, the Fair Housing Act, there's some prohibitations, right? So the FHA prohibits housing providers, i.e. associations in our case, from discriminating against applicants or residents because of their disability or the disability of anyone associated with them. And it prohibits treating persons with disabilities less favorably than others. And it also makes it unlawful for any person to refuse to permit, at the expense of the disabled person, what we would call reasonable modifications. And we'll get into more discussion of what maybe constitutes reasonable modifications. But essentially, these reasonable modifications, we can't refuse them if they're going to be happening on an existing premises that's occupied or to be occupied by that particular person, or if such modification may be necessary to afford such person the full enjoyment of the premises. Additionally, the FHA makes it unlawful for any person to refuse to make reasonable accommodations. And we'll talk about here in a couple of slides in the future about reasonable accommodations versus reasonable modifications. And so when we talk about reasonable accommodations, we're talking about rules, policies, practices, or services when those accommodations may be necessary to afford that person that has the disability an equal opportunity to use and enjoy the premises. Now, there's a couple exemptions, one of which is religious, and typically the FHA does not prohibit a religious organization from limiting the sale, rental, or occupancy of a dwelling, which it owns or operates, to persons of the same religion, or from giving preference to such person, unless the membership in the religion is restricted because of race, color, or national origin, or the dwelling has a commercial purpose. And interestingly enough, this also applies to not-for-profit institutions. The other exemption we briefly touch on is private clubs. So the FHA does not prohibit a private club from limiting the rental or occupancy to its members, or from giving preference to its members when the lodging is not open to the public, the lodging is incidental to the club's primary purpose, and the lodging is not for a commercial purpose. We also have some additional exemptions. Familial status. So the FHA does not apply to discrimination based on familial status with respect to housing for older persons. Some of you may be familiar with that term HOPA, H-O-P-A. Well, this is what it's referring to, those communities for persons that are 55 and older. Also, controlled substances. So the FHA does not prohibit conduct against a person because that person has been convicted by any court of competent jurisdiction of the illegal manufacture or distribution of a controlled substance. And my mind instantly goes to that show Breaking Bad. So if I was doing something naughty like that and had been convicted by a court of competent jurisdiction, guess what? The association could hold that against me. Finally, we have real estate. And so the FHA does not apply to certain real estate transactions where, and let me preface this by saying that this is an oversimplification, but the FHA does not apply to certain real estate transactions where the owner does not own or have an interest in more than 3 single-family houses at any one time, and that house is sold or rented without the use of a real estate broker, agent, or salesperson, or the facilities of any person in the business of selling or renting dwellings. I know, don't think too hard about it. It is a little bit complicated. When we compare the ADA to the FHA, there's some similarities, but there's also some differences. So under the ADA, it really prohibits discrimination based on disability, whereas the FHA prohibits housing discrimination on the basis of race, color, religion, sex, disability, familial status, national origin. Now, the ADA applies to areas of employment, government, public accommodations, hotels, things like that, commercial facilities, transportation, telecommunications. Whereas the FHA applies to private housing or housing that receives federal financial assistance. I'm thinking Fannie Mae, Freddie Mac, and state and local housing. And under the ADA, when we talk about animals, the ADA only provides for service dogs, which require particular training, and the occasional miniature horse. And even though it is a miniature horse, it is still a horse, of course. And primarily under the ADA, the miniature horse is used for those that have mobility issues or need steadying of their walk. Now we look over at the FHA under animals, and it really, the FHA provides for assistant animals, which are different than service animals, which includes service type animals and emotional support animals. And we'll talk about more of those differences here in just a few minutes. And let's talk about the terms handicap and disability, because essentially at the end of the day, they really mean the same thing. The FHA uses the term handicap, and the ADA uses the term disability. However, the ADA draws almost verbatim from the FHA. So for all intensive purposes, they do mean the same thing and are completely interchangeable. So when we talk about the term handicapped, it really means in respect to a person that they have a physical or mental impairment which substantially limits one or more major life activities. They have a record of that impairment, or someone views them as having such an impairment. And that's an interesting topic, and we'll get to that here in just a few minutes as well. And then interestingly enough, at the bottom, the term handicap does not include current illegal use of or addiction to a controlled substance. When we talk about the term physical or mental impairment, we talk about physiological disorders or conditions, cosmetic disfigurements, or anatomical loss that affects one or more of the bodily systems. I am not a doctor. I do not play one on TV. I will let you look through both the first and second of all of these potential conditions. And just know that it's not only psychological disorder or conditions or cosmetic disfigurements, but it could be also any mental or psychological disorder. And that could include mental retardation, a organic brain syndrome, emotional or mental illness. And this is an important one. When we talk about major life activities and how those are impaired, we're really talking about functions such as being able to care for oneself, being able to perform manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. When we talk about quote unquote has a record of such impairment, what we're really talking about is that individual has a history or a record or has been classified as having a mental or physical impairment that substantially limits one or more of their major life activities. When we talk about the term is regarded as having an impairment, really means that that individual has a physical or mental impairment that does not substantially limit one or more major life activities, but it's treated by another person as constituting a limitation, or that individual has a physical or mental impairment that substantially limits one or more major life activities, only as a result of the attitudes of others towards such impairment, or has none of the impairments defined, but is treated by someone else as having such an impairment. So it's kind of an interesting definition to these terms. Now, unlawful inquiries. There is, we call them in the legal world, no-nos. So keep this in mind. It's unlawful for an association to ask the following: if an applicant for a dwelling has a disability, or if the person that's intending to reside in the dwelling or anyone associated with the applicant or the resident has a disability, and we can't inquire about the nature or severity of a person's disability. And as I mentioned previously, we're going to touch on reasonable accommodations versus reasonable modifications. When we talk about a reasonable accommodation under the FHA, we're really talking about requesting a change, exception, or adjustment to a rule, a policy, a practice, or service. When we compare that to a reasonable modification is actually a structural change that's made to the premises. Perhaps it's a ramp to the front door. Perhaps it's grab bars in a bathroom. And if you look at the language there at the bottom of the slide, it's possible that a person with a disability may need either a reasonable accommodation or a reasonable modification, or both, in order to have an equal opportunity to the use and enjoyment of the dwelling. So it could be one, the other, or potentially both. So reasonable accommodation. So it's unlawful for any person to refuse to make a reasonable accommodation in rules, policies, practices, or service when those accommodations may be necessary to afford that handicapped person equal opportunity to use and enjoy a dwelling unit. And this includes both the public and common use areas. So in condominiums, the common elements, in HOA, the common areas of the community. Now, when we talk about reasonable accommodations in regards to assistance animals, generally that accommodation comes through and presents itself by asking for an accommodation to an association's pet restriction policy so that a disabled person may have an assistance animal within the community. So sometimes there are communities that have pet restrictions or may have certain kinds of pet restrictions based on weight. And so when someone asks, for example, if I was in a wheelchair and had, let's say, a dog that was over 20 pounds, but I needed that dog with great weight to be able to pull me around in the wheelchair, that may be a situation where I ask the association for a reasonable accommodation. Now we'll touch a little bit on association procedures. Now here's another important point to note. Under the FHA, it doesn't require that an association adopt any type of formal procedures for reasonable accommodation requests. However, associations can. And if they do, and if they have adopted formal procedures, that actually may aid these persons in making reasonable accommodation requests and may aid the association in assessing those requests. And God forbid, in the event of a later dispute, show proof that the request received proper consideration. A lot of times we say, if it's not in writing, it doesn't exist. So sometimes it's very good to document these things. We get to the third bullet point. The association may make the truth and accuracy of information providing during the process part of the representations made by a tenant under a lease to the extent that the lease requires the truth and accuracy. So we want to make sure that people are telling the truth. Now here's an important caveat. So a housing provider, i.e. associations in our case, may not refuse a request because the individual making the request did not follow any formal procedures that the association may have adopted. So if the association has procedures that says this individual must fill out forms A, B, and C, and this individual simply sends an email to the property manager, not a problem. In regards to the request itself, the disabled person is not entitled to receive a reasonable accommodation unless one is requested. Now, this may seem very straightforward on its face, but a lot of people just assume, oh, we've got to do this. Well, no, has that individual actually asked for an accommodation? And the FHA doesn't require that the request be made in any particular manner or at any particular time. So that request could be made by the person after the fact, after they've already moved into the house, after they've already moved into the unit. Also, the person with the disability doesn't have to be the one that makes the request. The request can be made by a family member or another individual that's acting on the disabled person's behalf. Additionally, the individual making the request doesn't need to mention the FHA. They don't have to use the specific words reasonable accommodation. But what they do need to make clear in their communication is to be able to have the person that's accepting that request understand that that person is making a request for an exception, a change, an adjustment to a rule, policy, or practice because of that individual's disability. And as I mentioned before, a request can be made by any time, even after the resident has brought the animal into the community. So that's another important point to keep in mind. Now we talk about, goodness, what type of assistance animal is it? So once the association receives an accommodation request for an assistance animal, the association has to determine, and they've got to ask itself, what type of assistance animal are we dealing with? And essentially, there's two types of assistance animals. There's service animals and there's support animals. Service animals. So under the ADA, the service animal is narrowly defined as any dog, right? Not just an animal, but specifically a dog that is individually trained to do work or perform tasks for the benefit of an individual with a disability. And that performing work or tasks really mean that the dog is trained to take a specific action when needed to assist that person that has the disability. Other species of animals, whether they're wild, domestic, trained, untrained, are not surface animals for purposes of the ADA's definition. And the work or task that's performed by the service animal must be directly related to that individual's disability. And this final bullet point here is another important note. So under the ADA, emotional support, comfort, well-being, companionship, those are not deemed work or tasks for the purpose of a service animal. And so we go through a series of questions here. And the first question is, hey, is this animal a dog? Well, yes, we'll proceed to the next question. Spoiler alert, it's on the next slide. But if the answer is no, then that animal is not a service animal, but it may be another type of assistance animal. Additional questions. Is it readily apparent that the dog is trained to do work or perform tasks for the benefit of an individual with a disability? And it's readily apparent when the dog is observed, let's say, guiding an individual who is blind or has low vision. The dog's pulling a wheelchair, providing assistance to someone that has stability or balance issues, or to someone who has an observable mobility issue. So if the answer to that is yes, it's readily apparent, then further inquiries, they're not necessary, and they're not inappropriate because the animal is a service animal. But if the answer is no, we've got to ask some additional questions. And one of those questions is this specific animal required because of a disability? Well, if the answer is yes, and the work or task is identified, for example, if I'm in a wheelchair and I have a dog that's pulling me, ideally we're granting the request. If otherwise it's reasonable, because the animal is going to be considered a service animal. If the answer is no, then that animal is not a service animal, but it could be another type of assistance animal. And if at least one action that the dog is trained to do is helpful to that individual's disability, then that dog should be considered a service animal. Also, if no specific or action is identified, the dog should not be considered a service animal, but may be another type of assistance animal. Let's talk a little bit about support animals. So if an animal is not considered a service animal, it may still be entitled to access if it is considered a support animal. So here we're really looking and zeroing in on the definition of what is a support animal. And it is a trained or untrained animal, right? Now remember with service, right? It's a dog or could be a miniature horse. In this case, we're talking about support animals, so it could be either trained or untrained. And it does work, it performs tasks, it provides assistance, or it provides some type of therapeutic support for a disabled person. And as I mentioned just previously, support animals, they're not required to be dogs. And they may be an animal that's commonly kept in a household, such as a cat, small bird, rabbit, hamster, or it could also be a unique animal that is not commonly kept in households, like a reptile. For example, if I suffer from PTSD and I have a 10-foot boa constrictor named Slinky, and every time I come home and take Slinky out of his cage, he tries to hug me to death. Don't know why that is, but you know what? It reassures me, it makes me feel love, and it helps obviate my symptoms from PTSD. So interestingly, there's a multitude of animals that could be determined to be support animals. So once we have identified the animal, we've got to really establish the disability. And we get into another series of questions. Does this person have an observable disability? Or does the association already have knowledge or information that would give them reason to believe that the person is disabled? If, I live in Happy Acres and I'm in a wheelchair and I'm going around the community in a wheelchair, well, then the association probably already has, at least visually, a reason to believe that I'm disabled. So if that answer is yes, then we proceed to establishing the disability-related need. And then if the answer is no, I don't have an observable disability, well, we've got to follow along to the next question. And for some of you that are asking, hey, what might constitute observable disabilities? Could include individuals that have blindness, low vision, deafness, being hard of hearing. They may have mobility limitations, some type of neurological impairment. And you can look at those other conditions down at the bottom of the page, but essentially those conditions would affect one or more of that individual's major life activities or bodily functions. Additional questions. Has the person requesting the accommodation provided any information to the association that reasonably supports that that person has a disability? So if that answer is yes, then we proceed to establishing the disability-related need. If the answer is no, there's been no information provided, then the association isn't required to grant the accommodation. Now, practice point here, life pro tip. Obviously, the association has to provide the person that's requesting the accommodation, right? We've got to give them a reasonable opportunity to provide that information to the association. And we have to let them establish evidence or create the nexus between their disability and the need for the animal. And when we talk about establishing disability, there's a multitude of ways that that can occur. Information could be shared that might include a determination of a disability from a federal, state, or local agency. The individual may get some type of disability benefits, whether it's Social Security or otherwise. They might get Medicaid, they might get veterans disability benefits. This individual might be eligible for housing assistance or receive housing vouchers. They might provide information confirming their disability from a healthcare professional, whether it's a physician, optometrist, psychologist, nurse practitioner, etc., so on and so forth. And we want to keep in mind too that a determination that a person does not qualify as having a disability for purposes of a benefit or other program doesn't necessarily mean that that individual does not have a disability for purposes under the FFHA or the ADA. So we can't assume. And a lot of times, just by the nature of one's condition, is automatically going to substantially limit one of their major life activities. And it's going to result in a determination of a disability. I'll let you quickly glance through some of these bullet points. I certainly won't go through every single one, but there's some of the most common: deafness, blindness, autism, epilepsy, HIV. The person may have a depressive disorder, maybe bipolar, some type of PTSD, schizophrenia, etc. Then we talk about establishing the disability-related need. So I've got a disability, and so how does that relate to my need for an assistance animal? So one of the questions we ask is, has that person requesting the accommodation provided information which reasonably supports that the animal works, it performs a task, it provides assistance, or provides some type of therapeutic emotional support in regards to that individual's disability? So if the answer to that is yes, then we would proceed to the type of animal being requested. If that answer is no, then the association isn't required to grant that accommodation. And again, the association must provide that person that's granting the accommodation with a reasonable opportunity to provide information that supports their disability-related need. So a lot of times, documentation that can support this disability-related need generally comes from a licensed healthcare professional. And it really establishes the relation or connection between the disability and the need for the assistance animal, right? And this is really important when the disability is not readily observable. and or the animal provides emotional support, right? I may suffer from tremors. My dog may be able to detect those tremors before they happen, but otherwise, I am a fully functioning individual. I'm not in a wheelchair. I'm not blind. I'm not hard of hearing. So it might be, that might be a non-observable disability unless I were to tell you. So for those non-observable disabilities and for those animals that provide emotional support, the association may ask for information that's necessary to conduct an individualized assessment of whether it must provide the accommodation. Oftentimes, the lack of that documentation may be grounds for denying that particular accommodation. Let's talk about this internet documentation. And Jeff mentioned this at the beginning of the program here. While there's been for a number of years, there's been a liberal interpretation. And I'm sure we're all familiar. We can do even a quick Google search on your own, hopefully not while I'm presenting, but afterwards, of where you too, for the low price of $19.95, can get all the documentations you need to give to your association to allow you to have an animal. And so there's definitely some websites out there that sell the certificates, the registrations, the licensing documents to any Tom, Dick, or Harry that answers a probably one, two, or three questions, participates in a short interview with someone who may be licensed or unlicensed, and as long as their credit card is chargeable, they get what they get. And not only in HUD's experience, but our experience, that documentation, a lot of times it isn't really sufficient by itself, and it doesn't often reliably establish that the individual has a non-observable disability or any disability-related need for an assistance animal. So, oftentimes the most reliable form of documentation is really a note from a person's healthcare professional that really confirms that person's disability or need for the animal. And this is especially true when that healthcare provider has personal knowledge of that individual. But it's important to keep in mind that, there are, especially with telehealth nowadays, there's a number of legitimate and licensed healthcare professionals that deliver these services remotely. So not everything that the association may receive from a website is suspicious or not authentic. But oftentimes, your associations may start, and we start seeing patterns in the names of providers. And oftentimes those providers are straight off the internet, and we know them to not, let's just say, be a less than legitimate source. Regarding official records, this is an interesting and important point. So, as I'm sure most of you know, documents provided to the association regarding a request for a reasonable accommodation, right, are to be maintained among the official records of the association because they are official records. However, we've got some privacy considerations. So under Section 718 for our friends in condo land and Section 720 for our friends in HOA land, there's certain protections, and members can't inspect and or copy certain official records of the association. And that includes information that's obtained in connection with the approval of a lease, a sale, or an other transfer of a unit or parcel. This is a big one. Medical records of unit owners, parcel owners, or HOA community residents. And of course, we have social security numbers, driver's license numbers, and other personal identifying information of any person. So even though these records may be official records of the association, right, they are protected. Now we talk about the type of animal. And we ask questions regarding the type of animal, right? So we've determined I have a disability. We've determined that I have a disability-related need. Now let's talk about the type of animal that I might be requesting. So first question to ask, is the particular animal commonly kept in households? And if that answer is yes, under most circumstances, the request should be granted. Remember, there's always exceptions to the rule. And if you run across a situation where that might be the case, we certainly suggest that you consult with the association's attorney. If the answer to the question is no, then the association is not required to grant the accommodation, except in very rare circumstances. So the associations do, to an extent, have some power. We'll touch a little bit on unique animals. So if the person is requesting to keep a unique animal, then the person requesting that has the substantial burden of demonstrating the disability-related therapeutic need for that specific unique animal. And this is times when we would encourage that person to submit documentation from a healthcare professional that confirms their need. And there's a couple of examples here, right? I might be allergic to a dog. So a dog may not be appropriate, and I may not be able to be around dogs. Without this specific animals, the symptoms or effects that I suffer from would be significantly increased. And in this example at the bottom, it talks about having, of all things, a trained monkey that performs tasks for a person that has paralysis that was caused by a spinal cord injury. So in this particular example, the monkey has been trained to retrieve a bottle of water out of the fridge, unscrew this cap, insert a straw, place the straw in the bottle so that the individual can drink. Maybe this monkey is trained to turn on and off light switches and retrieve things from inside kitchen cabinets. So in this case, this unique animal is permitted because the monkey can use its hands to perform tasks that, a dog simply can't. So God bless the opposable thumbs, right? Now let's talk about this for a moment, because I know this comes up and you probably have questions in your mind. What about an animal that poses a direct threat? So dear old Mrs. Smith, who's 90 years old and lives in condo T for Too Far Gone, makes a reasonable accommodation request. And for all things, the animal is a pit bull, right? And we know that a lot of other unit owners in the complex have teacup chihuahuas. And I can just imagine the property manager and the board of directors going, oh, dear God, this is going to end badly. But I want us all to take a collective breath here. So the association isn't required to provide a reasonable accommodation where the animal poses a direct threat that cannot be eliminated or reduced to an acceptable level through actions that individual takes or actions that person takes to control the animal. Now, here's where some people get a little upset about this, but I need to share this information because it literally comes up all the time. So a determination that an assistance animal poses a direct threat of harm to others must be based on an individualized assessment that relies on objective evidence, not subjective, but objective evidence about that specific animal's actual conduct, right? So it can't be based on mere speculation or fear about the type of harm or damage an animal may cause, and it can't be based on evidence about harm or damage that other animals have caused. And I know this causes agita to a lot of people out there, right? So even though Ms. Smith may have requested a pit bull, and pit bulls may not have the greatest reputation, it does not automatically impute to that specific pit bull that Mrs. Smith is asking and requesting about, because perhaps this may be the nicest pit bull in the world, and its conduct has been nothing out of the ordinary, right? And so just because we have our suspicions about the lineage of certain animals doesn't give the association the automatic denial powers. Let me say it that way. And again, it really comes down to that individualized assessment. And if the board has concerns, property manager has that concern, certainly include your association attorney in the conversation. Now, while Mrs. Smith may be entitled to have a pit bull, and if that pit bull, God forbid, harms, attacks, or is determined by the board through its actions to be a dangerous animal, right? The association does have the ability to have that animal removed. So keep this in mind. Hopefully this will bring some comfort to you. While someone may be entitled and has provided appropriate documentation to have a service animal, it doesn't mean that that particular person is entitled to that specific service animal, right? So we don't want trouble-making service animals in the community, and there are ways to deal with that. However, on the front end, we can't just simply automatically deny them because we think that such animal is going to become a problem. And as I alluded to earlier, there's an interactive process, right? So the association can't deny the request for an assistance animal simply because the board is uncertain as to whether or not the person seeking the accommodation has a disability or a disability-related need for an assistance animal. So before denying that reasonable accommodation request due to lack of information, we encourage the association to reach out and have a conversation with that person. And it's, called the interactive process because it's an interactive process, right? There's communication back and forth because we want to get a little bit better understanding, right? We don't want to simply deny someone who has a legitimate need, if indeed they do have a legitimate need and can establish that connection. That association, it can't insist on specific types of evidence of information which is provided or actually known to the association if it meets the minimum requirements of the FHA. And this is another important note. So disclosure of details about the person's diagnosis or their severity of a disability or their medical records or a medical examination cannot be required. This is another important one. So what if the association refuses that person's accommodation? Well, we got to look at alternatives, right? So when an association lawfully refuses a requested accommodation because it's not reasonable, the association really should talk with that person about the possibility of an alternate accommodation that would basically address their disability-related need without a fundamental alterations to the association's operation and may not impose an undue financial or administrative burden. If solution A doesn't work, well, hey, what about solution B, C, or D? Maybe we can arrive at a happy medium. And if an alternate accommodation would effectively meet that person's disability-related need as unreasonable, then the association must grant it, right? There's lots of ways to arrive at the finish line, and we want to work proactively with the person that's requesting. And we have some prohibited acts. So associations cannot require applicants and residents to pay a deposit for an assistance animal or to pay an extra fee as a condition of receiving a reasonable accommodation, even if the association charges a deposit for pets. An association can't ask an applicant to provide access to medical records or to medical providers or to provide detailed or extensive information or documentation of a person's physical or mental impairment. And then an association can't unreasonably delay a response to someone's reasonable accommodation request. And here's the issue with that, right? If the board sits on this for too long, and I understand unreasonable delay, right? That's subjective, right? Is in an unreasonable delay 1 day, 5 days, a week, 2 weeks, a month? So an undue delay in responding could be deemed to be a failure to provide a reasonable accommodation. So the association doesn't want to find itself in that position. So generally, when we are asked to review these type of documentation, we make it a priority so that the association can get that, approval or denial back to that requesting party as quick as possible. The board doesn't want to sit on it, right? Just because Mrs. Smith has asked for an accommodation for a pit bull and the board's uncertain or maybe a little nervous, or the residents have said, oh, she wants to bring in a pit bull. Don't sit on that request. And where can an assistance animal go? Well, the short answer to that is pretty much everywhere. So the person is responsible, the disabled person is responsible for feeding, maintaining, for the animal's veterinary care, and controlling the assistance animal. Now, the individual may do this and be able to do this on his or her own, but they could also do it with the assistance of family, friends, volunteers, or service providers. Interestingly, the association must modify or provide an exception to its no pet rule or policy to permit a person with a disability to live with and use an assistance animal in all areas of the premises where persons are normally allowed to go, unless doing so would impose an undue financial and administrative burden or would fundamentally alter the nature of the association's services. So a lot of times we get questions about, hey, this person wants to bring their animal into the lobby or onto the pool deck or some other common area or common element. And generally, the answer to that is going to be yes, that animal is allowed. Now, we'll talk about the board's I'll say appetite for risk, because some boards are more liberal in risk, some boards are more conservative. But the association's considering adopting rules governing conduct of assistance animals. Just remember that conditions and restrictions that apply to pets may not be applied to assistance animals, such as weight, breed, or size restrictions. So if, for example, I lived in the Teacup Chihuahua Condominium Association and they limited the weight of their dogs and breeds to 5 pounds, and I was in a wheelchair and I perhaps needed a cane corso to pull me around. I'm a bigger guy. I like to eat cheeseburgers. I admit it. Then those particular rules may not apply to my particular assistance animal. And given the board's authority to promulgate reasonable rules and regulations, a board does have limited ability to adopt rules and regulations that are applicable to assistance animals. But there's a big however here. And this is an area where it's gray, right? Sometimes the law contains a lot of gray areas, and this is one of them. So it's unclear whether it's acceptable for the association to promulgate reasonable rules governing assistance animal conduct, such as a rule requiring owners of those animals to pick up after the animal, or a rule prohibiting that presence of the animal within a pool area. So this is another area where you may want to involve and consult your association attorney. And even if there are, and the board adopts those rules and regulations, they may apply to support animals, but they might not apply to service animals. And I keep harping on this, consult your association's lawyer, but truly this is an area where an ounce of prevention is worth a pound of cure. And an assistance animal does not count toward the number of allowable pets. So if the association allows 2 dogs, the person requests an assistance animal and it's substantiated, then that particular owner could have 3 dogs, right? 2 dogs under the pet policy and then the assistance animal. And then violations of the Fair Housing Act. The plaintiff, or I'll call them the complainer, can establish a claim under 3 separate theories. It could be intentional discrimination. It could be under disparate impact, where an association's policy may not be discriminatory on its face, but it may negatively impact certain classes of protected people. Or number 3, failure to allow a reasonable accommodation or modification. And the complainer has a number of venues in which to bring the complaint. They can do it through an administrative agency. They can do it through a court of competent jurisdiction. And if they try do it through the division, and the division here is the Division of Timeshares, Condominiums, and Mobile Homes, they'll be instructed to file a complaint with an administrative agency. There's also HUD administrative hearings and federal district court. So just keep it in mind that there are a number of ways that someone can bring a claim against the association. They could essentially be entitled to attorney's fees and costs, as well as punitive damages. So the associations obviously want to avoid that as much as possible. And then finally, the action by the complainer. The complainer made at his own expense, file suit in federal district court within 2 years of an alleged violation, so long as the complainer has not signed a conciliation agreement with an administrative law judge, or has not also begun an administrative hearing. And again, a court can award actual and punitive damages, as well as attorney's fees and costs. Now, the rest of this presentation all revolves around cases of interest. We are running over on time, so I won't get into those, but you are welcome to read through them as you are like. And I will turn it back over to Jeff Solomon. Jeff, how did I do on time?
You are a wonderful storyteller. Nice job.
Tried to make it through.
So thanks for that. And folks, we have a couple of minutes. While I'm reiterating for everybody to go over into the chat area and click on the link to fill out the evaluation, Ben, take a look. There's not a lot of time, so just maybe look over in the Q&A if you have it open. Just pick a couple of questions to answer in a moment. While you're doing that, I just want to reiterate to everybody, if you haven't already done so, press the chat button simply so that it appears on your interface. And I'm going to again place the link for the evaluation into the chat in a few seconds. And then after you do that, you get you click on the link, fill out the evaluation. There'll be after you submit the evaluation, there'll be a confirmation screen. On that confirmation screen is a link to download the slides that Ben used, and also has all of those sample court cases that he was mentioning that you can read on your own. So Ben, pick 2 or 3 of those questions, and then we need to get ready for that next webinar, the last one of the day.
You got it. This is a question that comes up often. We believe there may be forged service and emotional support animal letters that have been turned into the office. Is there a way for the board of directors or the property management company to legally verify these. And this is in a no pets allowed high-rise condo. So
Call those guys from Vegas who analyze what's that show where they analyze the signatures to see if they're real?
right, I could take it to the pawn shop.
The Pawn Shop. I couldn't think
And,
of it. Pawn
and
Stars.
there's always an expert available in every conceivable way
Just
to
about.
verify. So, this is a great question, right? And you're not alone. So I totally understand. So is there a way to legally verify? Probably the best way is through doing some Google search, right? Is the healthcare provider that signed these documents, right? Are they actually licensed? Is this a documentation that has come from a different country? Is this documentation vague on its surface, right? So this would be certainly one time where I would want you to consult with your association and attorney because it may be appropriate in this situation to ask for a more specific documentation, right, from that person's medical provider as to their specific disabilities, that disability related need, and how that particular animal is going to obviate that person's disability. Um, and again, there's several of these questions are along that same vein, being able to challenge the internet certificates, right? And truly, this happens all the time. And oftentimes, if the association says no, or can through a Google search, right? Because they're out there. There are literally a handful of internet only, I'll call them document mills that do nothing but churn out these documents. And so the best way to approach that is having a conversation with your attorney and saying, hey, maybe this appears to be a little iffy on the surface. We need to dig a little deeper, but we don't want to run afollow of the law.
Let's
Uh,
do one more, and then we'll let everybody take a couple of minute break before the next class,
sure. Let me, oh, hang on.
if there are any pertinent ones, of course. Let's see here. You're right. A lot of them are similar.
A lot of them are similar. And there's one that says we're already past the scheduled time. Will it take much longer? My answer is no.
Yeah, once you do, folks, with any of our classes, once you do the evaluation, if I put the evaluation link into the chat, if, essentially it's after the final slide and you fill out the evaluation, then you can go. The Q&A part is not required. This is bonus time.
Perfect. Thank you, Jeff. At this point, I will sign off.
Ben, wonderful job. I'm looking forward to seeing you, and thanks for
Appreciate it.
doing this, my man.
Thank you, everybody, for tuning in and being patient. And I know this has been a long day of multiple seminars, but hopefully good and valuable information for you all. Thanks again.
Absolutely.